Hello everybody and welcome to this Evershed Sutherland PROPcast. I'm Gemma Irving-Lees, professional support lawyer at the Construction and Engineering practice at Evershed Sutherland. Our subject today is the Commercial Payments Bill. I'm joined today by Legal Director Lauren Morrison and Principal Associate Josh Curry, who both work in our Construction and Engineering practice. So Lauren, I wonder if you could start by introducing the Commercial Payments Bill, please.
Thanks, Gemma, and good morning, everyone. Thanks for joining us today. The Commercial Payments Bill is going to bring a significant shift in how payment risk is managed in construction contracts moving forward. In terms of headline points, it will abolish retentions in construction contracts. It will introduce a mandatory statutory interest. It will necessitate a 7-day window for a pay less notice to be served prior to the final date for payment. And it's also going to introduce new payment terms for public authorities and private bodies.
Thanks, Lauren. So let's start with the abolition of payment retentions. Josh, would you like to explain the background, please?
Yes, sure. And hello, everyone. So retentions in construction contracts have been unpopular with contractors for some time now. In practice, on construction projects, money is withheld from the contractor from sums that would otherwise be due to them. And this puts additional pressure on the cash flow. Now, typically 3 to 5% is withheld from each interim payment due whilst the construction project is ongoing, with half of that released back to the contractor on practical completion of the works, and the other half held and then released at the end of the defect rectification period. Now, with this draft legislation, change is very much on the horizon, and we do have a good idea now of how the proposed mechanisms will work in practice.
Thanks. So, Lauren, how is this going to work in practice?
Essentially, it's no longer going to be permissible to have a retention in a construction contract. Retentions are defined very broadly in the bill as the practice of holding back sums, usually as a percentage of an interim payment or the contract value, until some release condition is satisfied. So, for example, practical completion or making good defects. Important to note that when we're talking about construction contracts, we're talking about construction contracts within the meaning of the Housing Grants Construction Regeneration Act. And in fact, the new bill is going to amend the existing act to bring these changes into force. There's going to be a staged implementation period over 2 years, and that will start on the date that the relevant section of the act comes into force. And we don't yet know when that commencement date will be. We know that although the bill will be implemented in England, Wales, Scotland and Northern Ireland, the retention ban will not come into effect in Northern Ireland.
Thank you. So presumably pre-existing contracts are going to be protected to an extent because the ban will not generally affect contracts entered into before the provisions come into force?
Yes, Gemma, that's right, generally speaking, although there is an important sting in the tail. Now, under the bill, there's going to be a 2-year transition period during which retentions can still be used. However, any retention clauses which are agreed during or prior to that transition period become ineffective on what's being referred to as the last retention day, which essentially is 3 years from commencement date of the bill. So in effect, the legislation will create a cut-off point after which it will override contract terms which are already in place. And once that retention day then arrives, the retained sum, the retention, will become due to the contractor 30 days later, with the final date for payment being 30 days from the due date for public authorities or 60 days from the due date for other payers. Now, the parties can agree an earlier due date or final date for payment, but they need to do that in writing.
There's also going to be a new concept of retention debt, which is money wrongfully withheld or not paid back on the last retention day. If that happens, the contract will be treating as including an implied term, which gives the payee a fixed additional sum. And that sum is going to be the higher of £40 or 50% of the retention debt. So that could be significant if the retained amount is substantial. And obviously the payee is going to get statutory interest on that as well.
Thanks both. So I think it's clear that the bill stops parties attempting drafting workarounds after the transition period.
Yeah, exactly, because under the bill, variations of pre-existing retention clauses or related agreements, which are entered into before or during the transition period, will be void after the transition period unless they're more favourable to the payee. And any retention clause agreed after the retention period will simply be void. So the message under the bill is very clear. It's not just discouraging retentions, it's trying to take them out of the market altogether.
That's interesting. So what would be the impact of this going forward?
Abolishing retentions is certainly going to make things interesting commercially. Retentions are there to protect the employer so that the contractor is incentivized to correct defects. But there's also other examples of retentions being used. And for example, a common one is withholding a sum of money until collateral warranties are delivered in accordance with the contract. So employers are going to need to consider alternative security arrangements. And in terms of what we're hearing about right now, in terms of what those are looking like, it's going to be back weighting payment profiles to the extent you can do that under the new legislation, contra charges for discovery of defects, a fresh look at retention bonds probably, and of course parent company guarantees.
Yeah, and I think even with those protections, we can definitely foresee the process of practical completion being certified with a long snagging list, but becoming a lot riskier for employers. I mean, typically under construction contracts, practical completion is already a major pressure point on the job. Employers want early occupation, whilst contractors want to avoid delay and liquidated damages exposure. And therefore, in practice, what this often means is that practical completion is certified, but with a long list of outstanding snags to complete during the defects rectification period. But with the retention ban, the likely market response is probably going to be a more rigorous inspection process during the build, as well as just before practical completion. And as part of this, developer and employer clients are probably going to want to look at employing a clerk of works type consultant who can help them with that process during the build and inspection regime.
These pressures that Josh has spoken about are also familiar on infrastructure projects as well. So to the extent that those are going to be caught as construction contracts under the Act, operational start dates, grid connection milestones, commissioning dates, availability regimes, they can all create similar pressures to get to practical completion. And for energy and infrastructure projects, that probably means more negotiation around payment milestones, defect remedies, and completion testing.
Yeah, I think another point worth bearing in mind is that whilst main contractors will benefit from clients no longer being able to impose retentions, they will also lose the ability to withhold retention from their subcontractors. So that could leave them holding more risk after the ban. And they're probably going to be just as interested as employers and developers in finding alternative security structures. And in our experience, that's sort of particularly acute in the energy and infrastructure space, where main contractors are typically required to manage a deep supply chain with significant defects exposure across complex work packages.
Yeah, it's clear that this is going to have widespread implications, and it's interesting to note that the JCT are already updating their standard form contracts for the implications of the new legislation. And I think across the board, employers and contractors are going to need to look at their precedents and playbooks and make sure they're up to date for the new changes.
Thank you both. So moving on, the bill also introduces a mandatory change to the service of a pay less notice. Could you explain what's changing, please, Josh?
Certainly. So the bill amends Section 111 of the Construction Act and replaces what's called the prescribed period for pay less notices, which is essentially how long a party, the deadline for issuing one. And that at the minute can be as little as 1 day, and it's being replaced under the bill with a fixed 7-day period. Now, that might not sound like a lot and like a mostly procedural point, but it is likely to be a big deal for disputes. Therefore, once this change is made, parties will need to make sure that their contract wording is compliant, but also that their internal payment mechanisms work, because a 6-day period leaves a lot less time to issue a pay less notice if that's what's required. And as a result of this change, I mean, we do expect this to lead to a lot more adjudications, because parties are going to be particularly vulnerable to what's referred to as smash and grab adjudications, which are essentially disputes around technical breaches of payment terms. So to mitigate that, developers and also contractors will need to make sure that their payment notice procedures are properly watertight.
The bill also deals with final dates for payment in construction contracts. So for a relevant construction payment, the final date for payment is no more than 30 days after the due date if the payer is a public authority, and it's 60 days for other payers. And if a contract does not create that payment obligation, then that will be void, and the scheme for construction contracts will step in. There are some exclusions to that, and a relevant construction payment does not include transitional retained sums, payments under certain sections of the Procurement Act, and exempted contracts based on the size of the purchaser or supplier.
Thank you. So I understand the bill also attempts to stop attempts to contract out of statutory interest. Lauren, would you mind taking us through that?
Yeah, of course. So the statutory rate of interest is 8% above base rate. So that can become very meaningful very quickly on large construction balances. Any term that's going to try to exclude or vary the right to statutory interest on a qualifying debt will be void. And that includes imposing conditions around that, or changing the statutory interest rate, or changing the date from which interest becomes payable. Parties can, of course, agree other consequences for late payments, but they can't use drafting to strip out or dilute the right to statutory interest.
Yeah, and so on this point, and the public authority issue, I think that we see that as particularly relevant again for energy and infrastructure projects, where a lot of projects do involve public sector procurers or regulated interfaces with public and private structures. So it will be really key that 30-day payment deadline is properly reflected.
Agree, Josh, and those advising public authorities will need to make sure that clients understand they're on the stricter 30-day timetable and not the 60-day timetable that applies to other payers.
That's great. So finally, I believe there's been some changes to dispute resolution procedures as well. So Josh, what's the headline there, please?
Yes, so the bill introduces what's referred to as the Small Business Commissioner Adjudication Scheme, which is a separate adjudication mechanism from statutory adjudication under the Construction Act. And under this new scheme, small businesses, which meet certain size thresholds, can refer payment disputes to the Small Business Commissioner. And the decision from the Commissioner will be binding unless and until the matter is finally determined by legal proceedings or arbitration, as is the case already under the statutory adjudication regime. Now, this, whilst it does create a new route of redress for small businesses, it could create parallel or competing adjudication routes for them, especially where such businesses are in the middle of the supply chain. So those parties will need to carefully choose which option that they go for, and because of that, their dispute resolution strategy will need a bit more thinking up front, just to make sure that they choose the right route.
Yeah, I think it's fair to say there's some significant changes coming.
Yeah, absolutely. The final payment date provisions might not require huge change, because they sort of do generally reflect existing market practice in terms of 30 or 60-day final date for payment terms. But the reform to pay less notices is significant, and as I say, we do see it leading to an uptick in enforcement challenges and smash and grab adjudications.
I think the retention ban is where things get interesting. Employers will need to think harder about alternative security arrangements, and practical completion is also going to become a bigger pressure point. Although main contractors are going to benefit from clients no longer imposing retentions, they're also going to lose the ability to withhold those from the supply chain, which could lead to them holding more risk after the ban. And they'll be just as interested as employers in finding replacement security structures.
Thank you. So there's a lot of issues to work through then.
I'd say so. It's not just reactive changes to the legislation. I think it's about thinking through the implications as well. Ultimately, these changes to construction payments are going to affect project risk allocation, completion strategy, supply chain leverage, and security structuring.
Yeah, because of all those reasons, we're monitoring the bill as a team as it progresses through Parliament. And once we've got the final legislative text and the commencement date, then we'll need to move to amend contracts and reflect those changes. So we'll be keeping an eye on it, and we'll be providing further guidance as and when we have it.
Well, thank you both. That's been a very interesting overview of the Commercial Payments Bill, and I hope it's helpful to our listeners on some of the issues to think about going forward. If you do have any questions or you would like to discuss how these changes may affect your projects, please do get in touch with us or any member of the team. And that brings us to the end of this Evershed Sutherland PROPcast, and thank you for listening.